Okay, in this video, I will discuss about the proposed marital rape law. So what that means is that if there is a forced or violent sexual intercourse inside a marriage, that will also be considered as a crime of rape. As of now, it is not a crime as per IPC 376, Indian Penal Code section 376, which defines several, kind of scenarios where a rape is considered to have been committed. So it does not include any kind of sexual intercourse inside of marriage. Let's look at the reasons why it is being advocated that India should define marital rape as a crime. So one of the common statements we see, over on social media, Twitter, Facebook, people say rape is rape. The whole problem is, uh, how do you verify that the allegation is true? And because given the fact, even in rapes outside of marriage or crimes like that, it is sometimes they are found to be false, or sometimes the evidence is not there. So given that you're giving a kind of a license, to a wife to claim that she was raped, and there is very difficult to verify these kind of claims. Now, some people may say a woman will not make a false claim. That is just pure bullshit, because we have seen recently the so-called Braveheart Rothak sisters who claimed they were molested, and within a few days the truth came out that they have been doing this molestation drama for many many years altogether, and they have duped several people of money, over the years. And similarly, there was a Jasleen Kaur episode where she claimed that she was molested by this guy, and it was very soon found that it was, that thing never happened, and an eyewitness in both the cases said a totally different thing. But obviously, the media, the mainstream media, suppressed all those things, and they only played on 24 hours, the initial allegation, but they never portrayed the when the truth was coming out. So that is how things are kind of pushed in the media. And another reason is, the Indian government is facing pressure from international media as well as international agencies, probably United Nations and these kind of pressure groups and NGOs, because of India being portrayed as a rape capital, whereas the statistics are very clear that the crime in India is very low, and that includes the crime of rape also. But again, if you keep on showing one news 24 hours a day, and you keep on showing it both internationally as well as in India, soon enough people will think that rapes are happening in India everywhere. Whereas the truth is that many of these rapes are found not to be, I mean, nothing happened. Even the Badau so-called gang rape case, it was found, the people never raped. So let's look at the real reasons why this might be happening. And one is that, of course, the middle class Indians, they don't want to be seen as lagging behind other developed and civilized countries. So there is a pressure on government from within India also. And of course, international criticism, which I already talked about. The same Indian government, which a few months back gave a statement in Rajya Sabha that Indians are illiterate, the social conditions are different, they may not be able to understand what is marital rape, and there may be law misuse and whatnot. And within a few months, the bill has been kind of taken out from cold storage, or call it what you want to, and it will be sent to a committee, for deliberation. So that's how it is. Now let's look at the main, what's the condition of existing laws which were supposed to protect married women. And marital rape, of course, is another law to protect married women. So I just want to focus on the married women here. Dowry Prohibition Act 1961, it's been there for more than 50 years. Is it been used? Well, how often do you see in the newspapers that somebody got convicted under dowry prohibition? So whether dowry is prevalent or not prevalent, whether it is dowry or it is tridhan, that's a whole debate. But one thing is clear, that law has been mostly on paper, it's never been used. IPC 498A, it is basically cruelty to woman by husband or his relatives. Is it being used? Well, even the Supreme Court has mentioned it as legal terrorism in a judgment few years back. And in 2014, the Supreme Court went ahead and said that the police has to follow Section CRPC 41, and they should not arrest people immediately upon a IPC 498A complaint. So much was the misuse of this law to arrest people. Similarly, simply based on a complaint, that the Supreme Court had to intervene and they had to send a circular, make sure that Ministry of Home Affairs sends a circular to all the police stations in all the states. How IPC 498 is used? So in courts, because it is not being used to prosecute or criminally acquit or criminally, let's say, punish people, because of course it happens, maybe you can call it whether 5%, 10% or 15%. All the data is there inside the NCRB data. I will quote a judgment from 2013, which is a very latest judgment from the Supreme Court on case Srinivas Rao versus DA Deepa. So let me just quote from the judgment itself. Basically, it says that sometimes, the wife, she may file complaint, and because of some misguidance and whatnot, so her attitude was not correct. She could have taken it in a different way. The whole point is, if it was not a criminal complaint, but still wives are allowed to file such complaints. And that is how IPC 498 is used. From the same judgment, let's go forward, and the judgment says that IPC 498 is not compoundable, which means that it cannot be taken back once it is filed. However, Supreme Court is saying that if to the criminal code it seems that there is an element of settlement. Now, what exactly is a settlement? Can you really settlement a criminal case? Not in reality, but based on certain laws, section CRPC 482, these things are done. So if the High Court says that both the husband and wife have agreed to settle their case, even a criminal case like IPC 498A can be settled. What the settlement means is that the husband has to agree to give divorce to the wife, to her satisfaction, of course. So if she needs a property or 20 lakh or 50 lakh, whatever is based on the status of the parties or her demands, that will have to be done. And basically it just makes a mockery of the whole criminal law, because you are taking a criminal complaint and converting it into like a matrimonial dispute, and settling it in a civil manner. Again, from the same judgment, further the judgment says that judges with their expertise must ensure that this exercise does not lead to the erring spouse using mediation process to get out of clutches of the law. So who is the erring spouse? Of course, it's the husband, and there might be in-laws also involved. But basically, the husband should not be under any delusion that this so-called mediation is a neutral affair. He's not at the same level as his wife. She's the complainant, he's the accused. So don't even dream of being treated like a respectable person, because you are an accused in this whole process. Further, from the same judgment, it says, we recognize mediation as an effective method of alternative dispute resolution in matrimonial matters. So you can read the rest. The translation, the way I see it, is a criminal law can be converted into a so-called matrimonial dispute, which basically means, get ready for settlement. Otherwise, you may have problem getting bail. You will have to face the criminal prosecution, which will run for 6, 7, God knows how many years. So, better listen to the demands of your wife and settle. Otherwise, the courts will prosecute you criminally. So I will be very happy if the court said, we will prosecute you only criminally. There cannot be any settlement because it is a criminal case. But that's how a criminal jurisprudence has been converted into some kind of a barter and negotiation between husband and wife. Further, the judgment says in the end that efficacy of section 498A should not be diluted. So there is a discretion given to the criminal court, but at the same time, they have said don't dilute. Well, if you are allowing mediation to happen in a criminal case, I mean, where is the differentiation between a civil matrimonial case and a criminal case? I mean, you have already diluted the efficacy of Section 498A. So, I mean, if the public can be fooled into thinking that, yeah, the criminal law will not be diluted if you allow mediation, I think nobody can be fooled. It has already been diluted. So, Section 498A is a good tool for negotiation to get a divorce and get good alimony for wives, and that's how it will be used. So I'm just trying to just juxtapose how marital law can be useful. So I took the same judgment, the same paragraph, and just replaced IPC 498A with IPC 376 if and when the marital rape becomes a law in future. So this is from a future judgment, and what I'm trying to say is, in the future, how marital rape law will be used in courts, of course, is that it will be one more tool to give divorce and good alimony to your wife, because once she claims that you have raped her, you are not able to prove it, but at least the courts will have this so-called discretion. I mean, it's an actual discretion, not even so-called, that your wife has filed a criminal complaint against you. So if you are willing to, go for mediation and settle it out, well, we can allow that. But don't be under any kind of illusion that you will be allowed, bail or anticipatory bail, or you can escape the criminal prosecution, because it is a criminal case. So heads I win, tails you lose. If it's a criminal case, as long as you don't settle. But if you settle, it's not a criminal case anymore. So marital rape law, I believe it will be totally used as a divorce tool and as a negotiation tool in divorce. And nobody in the society who are trying to support this law, saying that rape is rape, should be under any illusion that it will be used to, punish people or punish criminal husbands, because the idea is not to punish. The idea is to, just get some brownie points with the international agencies and United Nations, and you know have a place for India in the Committee of Nations, that okay, you have the marital rape law, we also have a marital rape law, so we are not behind you in the ladder of you know evolution of the law, or evolution of civilization. So we are as good as you. But effectively speaking, I don't think in other developed countries they allow criminal law to be converted into a civil dispute or a marital dispute, and as a means to settle as a divorce. I mean, of course, it happens under Domestic Violence Act in other countries also, but not the criminal sections, as far as I know. So it is not a good sign to allow this kind of criminal and civil mixture of law. So, but unfortunately, that's how things stand. And even if the law is passed, it will never be used for criminal prosecution. It will be used for, 99% of the time, it will be used to settle and give divorce to your wife. I mean, or forcibly, get. Uh, I mean, your wife will get divorced from you, and she will get a good settlement, and that's how the story will end. If you like this video, please like, share the video, and subscribe to the channel. Thank you.